Magandang umaga, magandang araw po sa inyo muli. No? We are back live at inaantay na lang po natin ngayon ang live hookup doon sa paglilitis ni Tatay Digong. Meron lang pong counting delay no? Bago tayo mapigyan ng live feed dyan sa loob ng ICC. Gaya na aking sinabi po kanina, ito po ang kauna ng araw ng confirmation of charges na ang katumbas po nito ay preliminary investigation no, sa ating sistema. Ngayon pa lang po aalamin ng hukuman kung mayroong sapat na ebidensya o probable cause para magtuloy sa paglilitis ang kaso laban kay Tatay Digong. Ang mga paratang sa kanya, 3 counts of crimes against humanity. Ang crimes against humanity po ay isang either widespread or systematic na pag-atake lamang sa sibilyan na alam nung taong umatake na ang inaatake niya ay mga sibilyan dahil sila ay mga sibilyan. Ngayon, 3 counts po yan. Isa ay doon sa panahon ng Davao Death Squad na di umano ay merong 19 na biktima. Pangalawa, yung mga high-value targets noong unang taon na pagiging presidente ni Tatay Digong na di umano ay merong 14 na biktima. At saka yung sa Operation Tokhang sa Barangay Clearance Operations na merong di umano 44 victims. No? Mapapansin niyo po na napakakaunti na mga biktima kung ikukumpira doon sa di umanong mga naging biktima ng war on drugs sa sinasabi nila na 30,000. No? Biglang naglaong parang bula po yung 30,000 mga biktima. At ngayon, they're talking of 19 plus 14 plus 44. Na ang aking paninindigan kung kami naman po noong mga panahon ng Maguindanao Massacre ay nakapag-convict for 58 counts of murder, siguro po kakayanin din yan ng kahit sinong hukuman sa Pilipinas na litisin. Dahilan kung bakit hindi dapat nga na litisin ng ICC itong kaso laban kay Tatay Digong dahil una-una nga po tayo'y bumitiw na sa pagiging membro ng hukuman nung nagsimula ng preliminary investigation ang prosecution. At ang sabi po ng Rome Statute dahil wala naman pong sapilitan ng pagiging membro ng ICC, hindi rin po sapilitan ng manatiling maging membro, pwede pong bumitiw sa pagiging membro at ang obligasyon na makipagtulungan ay habang sa loob lamang ng 1 taon matapos na magdeposito ng instrument of withdrawal. Pero itong prosecutor po na dating prosecutor ng taga-Africa ay natulog sa pansitan at humingi lamang ng abiso para patuloy sa preliminary investigation sa pangalawang taon na nagdeposito ng instrument of withdrawal ang Pilipinas. Kaya nga po, bagamat nagkaroon ng desisyon ang pre-trial chamber na po pwede magtuloy sa preliminary investigation ng prosecutor, sa panahon pong binigyan na sila ng ganyang abiso, hindi na po miyembro ang Pilipinas at wala na talagang obligasyon na makipagtulungan. So, itong confirmation of charges po ay nagpapatuloy sa kabila ng patuloy pa rin nakabintin sa appeals chamber yung apilan ng kampo ni Tatay Digong na dapat ma-dismiss nga ang mga kaso dahil sa lack of jurisdiction. At kapag ito naman po ay sinang-ayunan ng hukuman, uuwi na po si Tatay Digong. Lahat ng mga proceedings kasama na itong confirmation of charges ay mapapaliwala dahil kapag sinabi pong walang jurisdiction, walang kapangyarihan na tumanggap ng ebidensya ang ICC bilang isang hukuman at wala silang kapangyarihan na maghusga kung guilty or not guilty si Tatay Digong. Kaya nga po sinasabi natin, nakapagtataka kung bakit minamadali ng pre-trial chamber itong confirmation of charges samantalang mas mabuting antayin nila kung ano yung resulta ng appeal sa chamber decision. Kasi nga kung decision ay lack of jurisdiction, wala talagang jurisdiction, wala namang mangyayari dito sa kanilang confirmation of charges. Mababaliwala yan, nasayang lang oras at panahon at yung gastos para sa pagpipresenta ng mga ebidensya dito sa confirmation of charges. Ang akin lang, bakit kasi minadali? Samantalang alam naman natin na mabilisan din naman magdesisyon ang mga iba't ibang chambers ng ICC, hindi naman umaabot sa taon yan. At siguro mas mabuti nga na antayin muna yung desisyon ng on the issue of jurisdiction kesa ngayon nagpapatuloy na posible na mabaliwala naman ito dahil nakabilib pa nga yung issue of jurisdiction. Now, meron ding issue doon sa isiniwalat ng ICC ng mga karagdagang co-perpetrators. Ito po ay controversial dahil meron na pong pulisiyang ICC na dapat sikreto. Sikreto yung service ng warrant of arrest sa kahit sinong posibleng masasakdal. At kapag ikaw ay kinilala bilang co-perpetrator, halos sigurado yan na merong warrant of arrest na hihingin sa inyo. Uulitin ko po, no, yung warrant of arrest ng ICC nakabase lamang sa mas mababaw na ebidensya, good grounds. Hindi gaya sa Pilipinas na hindi po pwede magkaroon ng warrant of arrest na ini-issue lamang ng hukuman unless merong probable cause na na-determine na ng piskalya. Dito po, ngayon pa lang gagawin yung determination kung merong probable cause at matapos nakulong na si Tatay Digong ng 1 taon na hindi talaga katanggap-tanggap dahil alam naman natin yung pagkakakulong na halos 1 taon sa isang 80 anyos na tao ay matinding parusa na rin po yan. Lalong-lalo na kung yung taong yon ay talagang hindi naman nanirahan sa isa't ibang bayan kundi sa kanyang bayan ng Davao, no, sa buong buhay niya. So anyway, ngayon po inaasahan natin na magpapakita ng ebidensya ang prosecution. Yan naman po ay obligasyon ng prosecution na ipakita ang may probable cause. No? Ang trabaho lang naman po ng depensa ay pulaan kung talagang sapat ba yung ebidensya na yan. No? Dahil ang talagang meron pong burden to prove a probable cause ay ang prosecution. Ang akusado naman po ay always presumed innocent. Kaya nga lang po dito sa ICC, dahil nga po mababa yung ebidensya na hinihingi para sa issuance of warrant of arrest at pinagkait si Tatay Digong ng interim release, para bagang naging biktima si Tatay Digong ng arbitrary arrest and detention. Kasi yung naunang tribunal for the former Yugoslavia, mahigit kalahati, binigyan naman po ng interim release. No? At hindi natin maintindihan kung bakit hindi kinilala ng ICC yung presumption of innocence at talagang hindi binigyan ng interim release itong si Tatay Digong. Dahilan na siya ay naparusahan na ng 1 taong pagkakakulong maski wala pang kahit anong napapatunayan na pagkakasala si Tatay Digong. So inaantay po natin ngayon ang live feed mula sa ICC. Meron po yung delay na from 15 to 20 minutes. Pero asahan po natin as soon as the live feed arrives, mapapanood nyo rin po dito sa ating Facebook at sa YouTube ang mga pangyayari sa loob ng ICC. I can assure you naman po na kapag nabigyan na ang lahat ng media ng live feed from the ICC, magkakaroon din po tayo ng live feed. Hindi po tayo nahuhuli sa pag-broadcast ng live feed. Sabay-sabay naman po nila ikakabit at hinahayaan muna nila magkaroon ng 30-minute delay kasi kapag merong gusto nilang gawing redacted na mga sinasabi ang mga abogado at mga testigo, meron silang pagkakataon na burahin yon dun sa broadcast. No? Ito po ay para pangalagaan yung integridad ng proceedings na yung mga bagay-bagay na hindi dapat isiwalat sa publiko ay magkakaroon silang pagkakataon na i-redact or panandali ang alisin sa live broadcast. No? Nag-aantay lang po tayo. Okay. Ayan, nag-aantay pa po tayo ng live feed, no? Well, anyway, nag-aantay lang po tayo doon sa feed na nanggagaling po sa ICC. In any case, meron pong 6 na mga Pilipino abogado na magmamasid. Hindi po ibig sabihin na sila po itatayong abogado, no? Kaya wag mo po natin silang asahan na sila po ay nakatoga at nandoon sa hukuman nakasama ng prosecutor. Sila po ay tagamasid lamang dahil hindi po sila kinikilala pa ang kanilang appearance ng hukuman. Ang nangyari po siguro ay talagang humingi ng abiso sa pamilya at pinayagan naman sila na magmasid ng proceedings nang sa gayon kung mayroong mga issue na may kinalaman sa Philippine law o di naman kaya mga facts na kinalaman sa mga pangyayari sa Pilipinas ay mapagbibigay alam yan kaagad doon sa abogado ni Tatay Digong na nananatiling si Nicholas Kaufman lamang at ang kanyang mga kasama. So, wag po nating asahan na mag-enter ng appearance yung 6 na abogado. Sila po yung kabahagi lamang ng audience. At hanggang sa panahon na talagang siguro kung gugustuhin ni Tatay Digong, talagang itatalaga sila mga abogado. No? Pero sa ngayon po, tanging si Nicholas Kaufman lang ang nakatayong abogado. Anyway, habang nag-aantay po tayo, ano ba po talaga ang dahilan kung bakit kinailangan na ang prosecutor ay hihingi muna ng abiso sa pre-trial chamber bago magpatuloy doon sa proseso ng preliminary investigation. No? Well, alam niyo po, nung pinag-uusapan nga itong Rome Statute, no, tumututulong Amerika. Ang sinasabi ng Amerika, napakakapangyarihan naman itong ICC prosecutor na ito dahil kaya niya ipakulong ang mga nakaupong mga presidente o prime minister miski wala siyang pananagutan. Ang pananagutan kasi sa Amerika pagdating sa prosecutor ay hinahalal nila ang mga prosecutors. So para lang maibsan yung concern ng Amerika, yun nga po, binuo nila itong pre-trial chamber kung saan hindi po pwedeng magpatuloy ang prosecutor sa kanyang mga gawain na walang basbas ng pre-trial chamber. So kaya nga po, ang kauna-unahang pagkakataon na hihingi ng abiso ang prosecutor sa hukuman ay yung paghingi ng abiso para magtuloy sa preliminary investigation. Yung naunang ginawa po ng prosecutor na preliminary examination, wala pong kinalaman na hukuman dyan. Yan po ay desisyon ng prosecutor lamang, kaya nga sinasabi natin na yung paghingi ng abiso para sa pagsimula ng preliminary investigation, ang tanging pagkakataon kung saan natitrigger yung jurisdiction ng hukuman. At yung 1 taon na ibinigay sa prosecutor para magsimula ng kanyang preliminary investigation, yan po talaga dapat bilangin doon sa 1 taon matapos na magbitiw sa pagiging miyembro ng isang bansa. Nangyari nga po sa prosecutor sa 2nd taon na siya nagsimula ng kanyang preliminary investigation dahilan para sabihin natin yung panahon na yon, maski siya binigyan na ng abiso, wala na, hindi na miyembro Pilipinas at hindi na talaga sakop ng jurisdiction ng hukuman. Lilinawin ko lang po na ang ICC po, kaya naman po yan nabuo dahil po sa mga pagpayag ng mga bansa na naging miyembro. Hindi po yan gaya ng Tribunal for the Former Yugoslavia o kaya naman yung Rwanda Tribunal na binuo ng Security Council. Yun po ang pagkakaiba niyan. Lahat ng miyembro ng United Nations ay dapat sumunod sa mga patakaran na binuo ng Security Council. At dahil ang Security Council ang bumuo doon sa Tribunal for the Former Yugoslavia at saka sa Rwanda Tribunal, lahat ng bansa ay may obligasyon na makipagtulungan doon sa mga tribunal na yun. Pero ang ICC po, binuo po yan sa pamamagitan ng tratado. Ang tanging nagbibigay ng jurisdiction dyan, yung papayag ng mga estado. At kung talagang hindi naman papayag ng estado, gaya ng hindi pumayag ang bansang Amerika, China at Russia, hindi sila po pwedeng pumilit na magkaroon ng jurisdiction. Pero nangyayari po sa mga kasaysayan ngayon, ay nagpupumilit pa rin na magkaroon ng jurisdiction ng ICC mas siya'y wala. Patunay, yung warrant of arrest na in-issue laban kay Putin, hindi naman talaga ever naging miyembro ng ICC ang Russia. Bakit sasakupin ang jurisdiction ng ICC si President Putin? Ganyan din yung reklamo ng Israel. Di naman sila ever naging kasapi ng ICC. Bakit merong warrant of arrest si Netanyahu, ang kanilang Prime Minister? So talagang ang ICC po ay kilala na doon sa paghihimasok na sila ay may jurisdiction maski mga bansa ay never naging kasapi ng ICC o di naman kaya ay bumitiw na sa ICC gaya ng karanasan ng Pilipinas na nung minsan tayo nga po ay naging kabahagi ng ICC pero tayo bumitiw na at dahilan para mawalan na ng jurisdiction ang ICC. Muli po, ang pinapanood po natin ay ang live coverage. Paparating po natin sa inyo ang mga pangyayari sa loob ng ICC sa unang araw ng confirmation of charges si Tatay Digong. Meron lang pong time lag bago sila mag-post ng live feed. At inaasahan natin ito na hindi naman ito lalampas ng 30 minutes. Nagsimula po ang pagdulig ng kaso ng SGs. So in a few minutes, we expect na meron na tayong live coverage. So standby lang po kayo. At ihahatid namin sa inyo ang pinaka-latest na pangyayari at hindi lang po yan. Hindi lang namin sa inyo ihahatid ang latest pangyayari, paintindihin po namin sa inyo kung ano nangyayari. Dahil ako naman po ang kauna-unang Asyano na natanggap sa International Criminal Bar o yung mga lawyers na accredited na humarap sa International Criminal Court. At sa ngayon po, 5 kaming Pilipino na kinikilala na mayroong kakayahan na humarap dyan sa International Criminal Court. So anyway, habang tayo nag-aantay po, sa mga nakalipas na mga buwan, may ilang mga bansa rin po na bumitiw na sa pagiging miyembro ng ICC. Yung Benin po. Yung Benin ay controversial kasi sinasabi nila na yung pagbitiw ng Benin yan yung kumbaga precedent kung bakit dapat magpatuloy yung jurisdiction ng ICC. Pero ang pagkakaiba po kasi, yung sa Benin, yung prosecutor ay humingi ng abiso para magpatuloy sa preliminary investigation sa loob ng 1 taon matapos nag-deposit ng instrument of ratification. Sa atin naman po, iba. Kasi humingi sila ng otorisasyon para magpatuloy sa preliminary investigation sa pangalawang taon na. So sa tingin ko, ang Benin ay dapat nating gamitin yung precedent para sa ating posisyon na wala na talagang jurisdiction ng ICC dahil kapag sinimula ng preliminary investigation sa pangalawang taon, wala nang miyembro na maiimbestigahan dahil tapos na nga po yung kanyang pagiging member ng ICC dahil nakasaad sa Rome Statute ng pagiging epektibo ng pagbitiw sa hukuman ay 1 taon matapos ma-deposit ng instrument of withdrawal. So magkakaiba po ang facts dyan, pero pareho pa rin po ang prinsipyo na kapag isang bansa ay hindi nakasapi, hindi na po pwedeng makingsapok ng jurisdiction ng ICC. Pag-usapan din po natin yung pangingidnap. Alam niyo po, lalo nang naging mas controversial ang kidnapping as a means of acquiring addiction. Ayan na po ang ICC, nagpapakita na po ang ICC ng live feed at sa tingin ko magkakaroon na tayo ng live feed from the ICC ngayon. No? Abangan po natin itong live feed na ito habang naayos ko po ang volume. Ayan na po ang ICC, nagkakaroon na po ng live feed na nanggagaling sa ICC, pero ito po ay isang PowerPoint presentation. Kung ako hindi nagkakamali, siguro ito po ay PowerPoint presentation. Ito ay live feed sa presentasyon ng prosecution kung hindi po tayo nagkakamali. Tignan lang po natin ang volume para ilabas natin ang volume. Nakasan natin ang volume dahil hindi natin naririnig ang volume. Okay. Tignan po natin. Ayan na. Hindi ko po makita kung ano yung sandali, pero titignan ko po dito sa isang computer kung ano naman yung nangyayari. Minutes delay nga po. Ayan na. At ang pinapakita natin ay yung panimula ng live feed galing po sa ICC. Tignan po natin ngayon ang mga pangyayari dyan. Well, nandyan po yan na kakasimula lang po ng live press link nila at ito po ay yun nga po, meron ng screen na nagsasabi na yung paglilitis, yung confirmation of charges ay ikakarry nilang live sa webpage ng ICC. Pero wala pa pong nangyayari dyan dahil may 30-minute report. Inaasahan po natin ngayon na nagsasalita na yung abogado, yung mga prosecutor at nagkakaroon na sila ng kumbaga presentation of summary kung anong mga ebidensyang
All rise, Leve.
Ayan na, nagsimula na po ang paglilitis. Nagkamasok na po ang mga ministrado. Ang tatlong huwes po ay tatlong babae, isang taga-Romania, isang taga-Mexico at isang taga-Africano. Hindi ko lang po maalala kung anong bansa sa Africa yun.
Please be seated.
Kaya nandyan po ang abogado ni Tatay Digong, si Atty. Kaufman. Taga-Africa. Hindi ko lang po maalala kung anong bansa. Nandyan po ang abogado ni Tatay Digong, si Atty. Kaufman. Ayan na po, magsisimula na ang paglilitis. Ito po ang chairman ng pre-trial chamber. Siya po ay taga-Romania.
Bonjour à tous. Good morning to all. I would like to welcome all those inside and outside of this courtroom. Madam Courtroom Officer, could you please call the case?
Good morning, Madam President, Your Honors. Situation in the Republic of the Philippines in the case of the prosecutor versus Rodrigo Roa Duterte, case reference ICC 0121, 0125, and for the record, we are in open session.
Merci beaucoup.
Thank you very much. I am now going to ask the parties and participants to introduce themselves, starting by Mr. Deputy Prosecutor. Could I please ask you to introduce yourself
Ito po
and
yung
to
end brief
confirm to me
appearances.
whether the list of your team members that I received before the hearing is correct? Thank you, Madam President. Your Honours. The Office of the Prosecutor is represented today by myself. I'm Nyai, Deputy Prosecutor. By my side, I have James Miriti, Case Manager. I have Mr. Julian Nichols, Senior Trial Lawyer. And behind us, we have Mr. Edward Jeremy, Trial Lawyer, Madam Robin Croft, Trial Lawyer, Madam Maria Berdenikova, Trial Lawyer, and lastly, Hannah Allen, Associate Trial Lawyer. These are the individuals comprising our team today, and I thank you. Thank you very much, Mr. Deputy Prosecutor. Now, before moving on to the defense, I note that Mr. Duterte is not present in the courtroom today. Indeed, on the 20th of February 2026, the Chamber granted Mr. Duterte's request to waive his rights to be present at the confirmation of charges hearing. Pursuant to Article 61(2)(a) of the Rome Statute and Rule 124 of the Rules of Procedure and Evidence. In this decision, number 387, the Chamber concluded that the conditions contained in the provisions were fulfilled, namely that Mr. Duterte has the right and knows he has the right to be present at the confirmation of charges hearing and knows the consequences of waiving this right. However, Mr. Duterte's counsel is present today to represent him. Counsel, could you please introduce yourself and confirm to me that the list of your team members that I received before the hearing is indeed correct?
Good morning, Madam President. Good morning, Your Honours. Indeed, the list before you is correct. May I introduce my team? To my left, I have Dr. Dov Jacobs. To my right, I have Ms. Avnik Sethi. Sitting next to her is Maître Alexandre Dezev-Dabi. Behind him, Attorney David Rankati. Sitting next to him, Maître Sandrine de Sena. And our two further lawyers, we have Nicolas Rousseau and also Kaylin Chen. And if Your Honor will permit me, there are also Filipino attorneys who are attending and supporting us today, and I'll briefly mention their names. Maître Salvador Mediadea, who Your Honours are familiar with from the initial appearance. Attorney Martin Delgra, Attorney Silvestre Bello, Attorney Alfredo Lim, Attorney César Doulay, and of course, Attorney Salvador Panello. Thank you very much.
Merci beaucoup, maître. J'ai envie de...
Thank you very much, Counsel. I would like to now call upon the legal representatives of victims to present them, to introduce themselves and confirm to me that the list of your team members I received before is correct.
Proceedings are represented today by Mr. Joel Butuyan, Mr. Gilbert Andres, myself, Paulina Masida, and I confirm the list of our jurists who assist us today as provided to the court officer. Thank you very much.
Merci beaucoup, maître.
Thank you very much, Maître Masida. Thank you. On my right, I have Judge Rain Adelaide. And I have Judge Adelaide Sophie Alapina Gansu, and to my right I have Maria del Socorro Flores Liera. And I am Julia Antonuela Motok, and I am the presiding judge in pre-trial chamber 1 of the court. This hearing concerns the confirmation of charges by the prosecution against Mr. Duterte. At this stage of pre-trial proceedings, the OTP alleges that Mr. Duterte is responsible for the crimes that the court officer shall read out shortly. The Chamber shall not take any decision with regard to the guilt or innocence of Mr. Duterte during this hearing. Indeed, the role of the Chamber is to determine whether there is sufficient evidence to establish substantial grounds to believe that Mr. Duterte committed the crimes with which he is charged. If all or part of the charges are confirmed, the Chamber will refer the case to trial, where the trial chamber will decide upon the innocence or guilt of Mr. Duterte. The general principles to be applied at the hearing are as follows. The suspect, in accordance with Article 66 of the Rome Statute, the suspect is considered to be innocent until his guilt has been proven by the court. The burden of proof is upon the OTP, which must produce sufficient evidence to prove the charges against Mr. Duterte at the required standard of proof at Article 61, paragraph 7 of the Rome Statute. Finally, the defense enjoys, or the suspect enjoys, all the rights listed at Article 61, paragraphs 6 and 67 of the Rome Statute. The hearing shall take place according to the schedule contained in the order dated the 26th of January 2026, document number 359. The parties and participants must respect the allocated speaking times indicated in this order. I would like to remind the parties and participants that oral remarks must be concise and that repetition of previously presented arguments should be avoided. In addition, in order to facilitate the work of the interpreters and ensure the proper transcription of discussions, please make sure that your microphone is on every time you address the court. And please speak slowly and mark pauses between each sentence. Generally speaking, the hearing will be held in open session, and parties and participants will refrain from mentioning the names of victims and witnesses. They will only refer to them by their pseudonym or their code. In order to avoid the disclosure of any confidential information, notably with regard to witnesses and victims, the parties and participants will clearly indicate whether their submissions can be presented in public or whether they deem it necessary to move into private session, notably when referring to items of evidence. The parties and participants will clearly indicate when it is no longer necessary to remain in private session. With these rules in place, we can now move to the reading of the charges in its shortened form, indicating the charges against Mr. Duterte. The full version is available publicly on the internet site of the court. The defense has not raised any objections in this regard. I would like to remind the public that the charges that shall be read out in a few seconds comprise allegations raised by the Office of the Prosecutor that the Chamber shall analyze in order to decide whether the evidence presented by the Office of the Prosecutor is sufficient in order for these charges to be confirmed. Madam Courtroom Officer, would you please read the charges?
The prosecution charges Mr. Rodrigo Roa Duterte with 2 counts of murder and 1 count of murder and attempted murder as a crimes against humanity committed between 2013 and around June 2016 and between around July 2016 and September 2018 in the Republic of the Philippines as follows. Count 1. Murder of 19 victims alleged to be criminals, including 3 children, who were killed in or around Davao City in the Philippines between 2013 and around 2016 by members of the Davao Death Squad, while Mr. Duterte was the mayor of the Davao City pursuant to Article 71A of the Rome Statute. Count 2. Murder of 14 victims labeled as high-value targets for their alleged criminality, who were killed in locations across the Philippines between around July 2016 and July 2017 by a network of perpetrators comprising state actors and others, referred to as the National Network, while Mr. Duterte was the President of the Philippines pursuant to Article 71A of the Rome Statute. And count 3. Murder and attempted murder of 45 victims, comprising 43 murders and 2 attempted murders of persons alleged to be criminals, including 3 children who were targeted in barangay clearance operations in locations across the Philippines between around July 2016 and September 2018 by members of the National Network, while Mr. Duterte was the President of the Philippines pursuant to Articles 71A and 25(3)(f) in respect of the attempted murder of the Rome Statute. The prosecution alleges that Mr. Duterte is individually criminally responsible for all 3 of the above counts as follows. First, as an indirect co-perpetrator pursuant to Article 25(3)(a) of the Rome Statute. At least between 1st November 2011 and 16 March 2019, Mr. Duterte and his co-perpetrators shared a common plan to neutralize alleged criminals in the Philippines, including individuals perceived or alleged to be associated with drug use, sale, or production, through violent crimes including murder. Mr. Duterte and his co-perpetrators implemented this common plan through the hierarchically organized structures of the Davao City Police, and Davao Death Squad, and then the National Network.
Ang
Within
nangyari
the
po ngayon
framework
ay
of the common
pagbabasa
plan,
ng mga
Mr.
paratang
Duterte
nabanggit
made
natin.
essential contributions to the crimes in counts 1
Tatlo po
to
yung
3
mga paratang
by
nila.
A.
Yung panahon ng Davao Death
Designing
Squad,
and disseminating the police to neutralize alleged criminals,
yung mga high-value
both in
targets
his role
sa
as a mayor of the Davao City
ng presidente ni Tatay
and also
Digong,
during his
at
presidential
saka
campaign
yung barangay
and
saturate
as a
campaign
president,
yung operation
including by endorsing the anti-illegal drugs campaign Double Barrel,
sinasabi nila ay ang pananagutan ay
establishing and
pag-indulso
overseeing the DDS,
at yung
C.
pagbubuo ng Davao Death Squad,
instructing and authorizing violent acts including murder to be committed against alleged criminals,
at yung pag-utos na
including
pagpatay sa mga
drug dealers
pinaghahanang
and users,
kriminal.
D. Providing personnel and other necessary logistic resources such as weapons, including those to be used in the execution of the crimes. E. Appointing key personnel to positions which were crucial to the execution of the crimes. F. Offering financial incentives and promotions to police officers and hitmen.
At sinasabi rin nila na
Alleged
si
criminals.
Tatay Digong ang bibigay
G.
ng pamamaraan
Creating and
para
maintaining
mapatay
a
ito.
system in which perpetrators knew they would be protected,
At sila, si
including
Tatay
through
Digong daw
promises of
hindi man
immunity
magbawa ng
and shielding
sistema
perpetrators
para doon sa
from
mga
investigation and
pumapatay
prosecutions.
na hindi maparusahan.
H. Making public statements authorizing, condoning,
At
and
yun,
encouraging
pagsasalita
killings of alleged
na
criminals,
nagkukondone or
both as a mayor of the Davao
tolerate
City and as a president
mga
of the
pagpatay,
Philippines.
Bilang isang mayor ng Davao
I.
at saka bilang presidente ng
Authorizing
Pilipinas.
state actors to take part in the anti-drugs campaign and temporarily revoking such authorization, including to placate public
At
outcry.
yung pagbibigay otoridad
J.
sa mga
Publicly naming individuals
Ente ng,
and holding up charts from lists
Estado
of alleged
na
criminals,
labanan nito
including
mga
so-called high-value targets,
pinagdinalaan na
some of
nangangalakal
whom
sa
were
drugs.
subsequently killed. Second, in the alternative, Mr. Duterte is charged with ordering and/or inducing the charged crimes pursuant to Article 25(3)(b of the Rome Statute, and/or aiding and abetting these crimes pursuant to Article
Kung hindi
25(3)(c
raw
of the Rome
mapapatunayan na
Statute.
in-order to ni Tatay Digong, pwede pa rin siya mapanagot dahil siya ay gumawa ng pamamaraan para nga
Merci, Madame la
magawa nila
Greffière.
itong mga bagay-bagay.
Thank you, Madam Courtroom Officer. With regard to objections and observations under Rule 122, paragraph 3 of the Rules of Procedure and Evidence, the Chamber notes that the defense submitted a number of written observations, and the last of which was on the 16th of February 2026, to which the OTP and the legal representatives of victims responded, respectively, on the 17th and the 18th of February 2026. On the 20th of February 2026, the Chamber dismissed, in its public decision, the defence's objections. In specifying that the defense and the Office of the Prosecutor are not permitted to reiterate the same arguments already presented in the filings mentioned, that they filed to date in this case, I will now ask if the parties wish to make any oral submissions on this point before moving to the opening statements. Mr. Deputy Prosecutor? Mr. Nyang, we do not have any submissions to make in this regard. Thank you very much, Mr. Deputy Prosecutor. Counsel?
Merci beaucoup, Maître Kaufmann. Donc, on peut maintenant passer à la phase.
So we can now move on to stage 2,
Yan.
namely
Matapos
the
po
opening
ang
statements, and I hand
pagbasa
over to the Office of the
ay
Prosecutor.
magkakaroon na
Mr.
ng
Deputy
opening
Prosecutor.
statement. No? Binibigyan po yan ng 1 oras at kalahati. Para sa
Madam
opening
President, Honorable Member of the Bench, all those following these proceedings inside the courtroom and outside, and especially those in the Philippines. Today marks an important day for international justice for the people of the Philippines, for the victims, and for this court. The commencement of the confirmation hearing against Mr. Rodrigo Roa Duterte is a reminder of the court's unwavering commitment to its mission to investigate and prosecute individuals for the most serious crimes of concern to the international community and to bring justice to the thousands of victims of the mass crimes and atrocities perpetrated in the Philippines. It is also a reminder that those in power are not above the law. Your Honors, over the course of the next 20 minutes or so, I will provide an overview of the evidence in this case that demonstrates that Mr. Duterte is responsible for the charged crimes. And my team will then develop aspects of this evidence in more details. This case before you today, it is before you today because there are substantial ground to believe that Mr. Duterte is criminally responsible for those 3 counts of murder just spelled out and attempted murder as crimes against humanity. These charged crimes were committed during the time within the court jurisdiction, which is between the 1st of November 2011 and 16th of March 2019. At first, they were committed in and around Davao City, where Mr. Duterte was a mayor, and then expanded across the rest of the Philippines when he became president. Mr. Duterte is charged with 49 incidents of murder and attempted murder of 78 victims, including children. These murders and attempted murders were part of a widespread and systematic attack that overall resulted in the killings of thousands of civilians across the country during the relevant time frame. Thus, the charged incidents are merely a fraction of the overall criminality that resulted from Mr. Duterte's so-called war on drugs. What is Mr. Duterte's core contribution? Your Honors, Mr. Duterte played a pivotal role in the commission of the charged crimes. His contribution was essential, as he was at the very heart of the common plan to use his words, to neutralize alleged criminals in the Philippines, including through murders. The victim included individuals associated with or perceived to be associated with drugs. One of the first things Mr. Duterte did when he became the mayor of Davao back in 1988 was to create the infamous Davao Death Squad, otherwise known as DDS. As you will have seen from the prosecution pre-confirmation brief, Mr. Duterte personally instructed Death Squad members that their mission was to kill criminals and suspected criminals, including drug users and dealers, also referred to as drug pushers. The death squads carried out this mission well into the charge period through 2011 to 2016, perpetrating the crimes charged in count 1. Your Honors, Mr. Duterte's criminal plan and his intent were no secret. He not only shared them with his co-perpetrators and members of the death squad, but also made them abundantly clear to the general public in the numerous public statements that he made time and again. During his presidential campaign, Mr. Duterte explicitly vowed to implement the common plan to neutralize alleged criminal nationwide if elected. This was his program to be elected. He publicly announced his intention to eradicate corruption, criminality, and drugs in 3 to 6 months. And this is what he said. I quote, "If I become the president, I will order the military and the police to hunt down the drug lords, the big ones, and kill them." That's what he said. And this can be found at tab 12 of the prosecution list of material. Similarly, when speaking about druggies, I quote, in a televised interview in 2015, this is again what he said. "If I become president, you will all get wiped out. I will order your execution within 24 hours. That's what he said. That I quote directly from his word. And this quote can be found at 19.2 of the prosecution list of materials, ERN PSL OTP 401684, page 003, and these are the lines 82 and 83. And elected he was. And becoming president on 13th of June 2016, this provided him with the opportunity to follow through with his promise and to expand extrajudicial killings of alleged criminals beyond Davao and across the rest of the Philippines. He did this through the implementation of the National Anti-Illegal Drug Campaign, better known as Duterte's War on Drug, and its project, Double Barrel. These were carried out by the national network consisting of law enforcement personnel working together with non-police assets and hitmen. Mr. Duterte authorized murder and personally selected some of the targets. During the mayoral period, when he was mayor, his clearance was required for the DDS to carry out the killings. Essentially, members of the DDS needed Mr. Duterte's green light to murder. And during the presidential period, Mr. Duterte has continued to personally identify some of the targets, including by publicly naming those he claimed were involved in illegal drug trade or in other forms of criminality. He also identified targets by holding up a list containing their name. And if you are on the list, you will be killed. And this was a word of one prosecution witness. And this evidence can be found at tab 54 of the prosecution list of materials, ERN PHL OTP 00015 page 0009, and the relevant lines are 260 to 261. Mr. Duterte provided moral and financial support to the direct perpetrators as well. In a 12 December 2016 speech, Mr. Duterte admitted that he used to ride around Davao on a motorcycle looking for trouble, so he could kill. And he said, and this again his own word I'm quoting here, in Davao, I used to do it personally, just to show the guy that if I can do it, why can't you? And these are his own words. And this quote can be found at tab 16.1 of the prosecution list of material, ERN PHL OTP 000155547 at 0002 lines 7 and 8. And the evidence show that Mr. Duterte's Davao City Mayor office provided some member of the DDS with a regular salary. Financial rewards were also given to direct perpetrators in the form of cash per head of killing. And at a press conference in 2013, Mr. Duterte stated that shoot to kill orders and reward are, and I quote him, are legitimate tools of government to fight lawlessness. This is his own word. And if he surrendered to me or his carcass dead, then I double the price. And again, and that was what he boasted. This quote can be found at tab 17.2 of the prosecution list of materials, PHL OTP 000094932 at 0002, and the relevant lines are lines 7 to 11. Deaths of drug personalities killed in anti-drug operation were
Voter, Abi, Blood.